So at this year's meeting, we'll be presenting Chapter 5 of the Restatement, which deals with investment arbitration. It deals with investment arbitration, but you might even consider it a sort of piggyback chapter. I think the major work, the hard work that was done in writing that chapter was to tease apart at what point is investment arbitration unique and deserving of special provisions that parties need to look at when they have this kind of case, and at what point do parties just need to go to the main core provisions that are in the other chapters of the Restatement, and providing clear guidance on that. So you might think of Chapters 5's primary accomplishment as being a traffic signal. Where do you go to look for the right answers?
There was, even at the beginning of the project, some debate about whether investor-state arbitration belonged in this restatement. And you may think that is peculiar because this restatement is entitled International Commercial Arbitration, and by most criteria, investment is a commercial activity.
When I say commercial, it's in a sense ambiguous. Most narrowly, it applies to business arbitration in international commerce. But if you think about it, investment arbitration, right, disputes between investors in countries also is a commercial undertaking, right? They're investing in a country that's commercial.
The problem arises because there's a usage that has developed to distinguish between arbitration that is contract-based and arbitration that might not be contract-based, and that is peculiar to investment. So we speak of commercial arbitration and investment arbitration.
For whom the restatement is written, I think the answer is everybody, but primarily for judges, not necessarily federal judges, because federal arbitration law is preemptive and in many cases is binding on state courts, in part because it's a treaty-bound jurisprudence. It's also for lawyers who want to think about these issues and perhaps find some support for what they think is a better reasoned position than where the law might be at the moment.